everybody. Thank you for joining us. I know we had a little bit of some technical difficulties to get started with, but we're here and we're ready to go. So I'm hoping that everybody kind of stuck with us for a little bit. So we're talking a really interesting topic tonight, ED and legal issues. And we're going to tell you a little bit about how to participate and introduce our guests in just a bit. But my name is Rachel, and I am a school psychologist. I'm working right now in the state of Maryland. Rebecca?
Hi, I'm Rebecca. I'm a school psychologist working in the state of Connecticut. I'd like to tell you guys how to participate. If you are on Facebook, please just comment or message me on School Psyched, Your School Psychologist, or the School Psyched podcast page. I'll be looking for notifications there. Also on Twitter using the hashtag Psyched Podcast. I'll be looking out for you. I'm hoping you have some questions or things to share. And here is our maternity leave replacement, Eric.
Hi, I'm Eric, and I'm a maternity leave sub for Anna. I'm a school psychologist in Central Connecticut.
All right. So I'm going to introduce our guest tonight. And shout out to Anna if you're watching. She had her baby. She's doing great. Okay. But Dr Huberty, PhD, ABPP, is professor of school psychology at Indiana University. He's a licensed psychologist, is board certified in school psychology by the American Board of Professional Psychology, and is a nationally certified school psychologist. He has a range of practical experiences, including being a school psychologist and pediatric psychologist, as well as working with Head Start, children with moderate to severe developmental disabilities, and in community mental health. His primary teaching areas are developmental psychology, social emotional assessments, and cognitive behavioral therapy. His research interests are in internalizing problems, especially anxiety and depression, in children and adolescents. For the past 28 years, he has been an independent hearing officer for due process hearings under IDEA, having presided over numerous proceedings, including students known or suspected to have emotional disabilities. So, welcome.
Thank you.
That's quite a resume you have there. So we're really excited to have you. And I know you have a PowerPoint too, so I'll let you kind of get to it, just because I know we're short on time.
Right. Well, again, my interest in this is, and the reason why I put all the things into the introduction is because I have a sort of a unique blend of experiences blending school psychology, and legal issues. So I think it makes it kind of unique. And I've done several presentations like this. In fact, I think Rachel attended one or more of mine in the past at NASP. But the reason I'm really interested in emotional disturbance, and I'm very interested in legal issues, so what I thought might be useful would be to talk about some of the practical and legal issues associated with ED. Now, I recognize that in some states your definitions may be slightly different, but it's been my experience that most of the definitions are very similar to the federal one, so I don't think I'll be too far off most of the time, because most states I've seen use the basic definition that the federal government uses with maybe some slight wording changes. In Indiana, we call it emotional disability, for example, but the basic language is pretty much the same. So I think a lot of this will apply. However, there may be differences in your state law, and in fact, on the last page, I offer a disclaimer because I'm not really offering legal advice, but just some of the things that I've run into that you may find useful. This is actually a very short version of a much longer workshop I've done. So what I want to do is just share some of the major points, particularly since we got a late start, and then share some of my perspectives, and if we have questions as we go along, that's absolutely fine. I typically get lots of questions about this. I'll start by really talking about the IDEA definition, and you see it there on the slides. So I won't go through a lot of it in detail because most of you are familiar with it. I really sort of talk about some of the problems with the definition, and many of you who have had to deal with the ED, and I'm sure many of you have. It's to me, it's probably the most difficult of all the areas, the federal definitions, and legally, it's very difficult. It's very challenging because just because of the ambiguity and just the differences in the way people interpret the criteria and the definition and so on. We started talking about some of the initial problems with this, and again, feel free to chime in. The first is inability. The problem is that if you really applied an inability standard the way some people did way back in the 80s, it basically was to say that you couldn't learn anything, or that it would be an absolute lack of ability to learn or whatever, and that's not really what the law means. In the federal law, there's the distinction between the letter of the law and the spirit of the law. And the spirit of the law is really, I think, in many respects more important, although many people get stuck with the idea that it's a literal interpretation. When I started doing legal work many years ago, in fact, I said to my mentor, who's still my mentor, I was sort of expecting the law to be pretty cut and dried, and he sort of smiled at me like, "You've got to be kidding." And I found that out after I got working in more. It's like it's much more ambiguous. The law is much more ambiguous than you think. And this particular area is particularly ambiguous. In fact, my very first hearing I did was on emotional disturbance at that time in Indiana. We called it emotionally handicapped. But the things that I would talk about this a little bit from a legal perspective, and share some of my own hearing experiences. Basically, as you know, you have to make sure that that the inability to learn is not due to things other than emotional disability or emotional disturbance. In other words, the child has to be able to not be able to function because of the emotional behavioral problems, not because of anything else. That's the first part under criterion A. Criterion B, this is the problem here.
Tom, sorry to interrupt. I'm not sure if you are meaning to screen share yet, but the slides aren't up. But I did want to also let people know that Dr. Huberty's slides are in our shared resource drive in the Google Drive in the ED file for everybody out there. But they're not on the screen right now. I'm not sure if you're meaning to share them now as you're talking.
Okay, well, I can, again, this is new to me, so I hopefully can find them here and screen share. And
okay, great.
There.
Awesome. And quick question, because I'm going to have a million questions. And
okay, that's fine.
Could you just really quickly talk about, as school psychologists, some of us may not have had any dealings with a hearing officer yet and might not understand the importance of, what a hearing officer does, and especially in relation to us, if we haven't been through that experience. Could you just briefly, what does a hearing officer do, just so everyone knows? Okay,
basically what a hearing officer does, a hearing it's sort of like a bench trial like you see on TV. There's no jury. It's just a judge, and the parties generally it's a judge is in the middle. One party is on one side, represented by an attorney almost always, and the other party. So you have the parent and the school, each represented usually by an attorney, one on each side, and it really is somewhat like a bench trial like you see on TV. It follows a lot of the same rules, a little more relaxed, a little more informal. But there is testimony presented, there are exhibits presented, and so what the hearing officer has to do is basically preside over the hearing, make judgments, and make rulings, and just basically hear the evidence. When that's all done, when they finally get the hearing done, then the hearing officer writes a decision, and that's binding, which may or may not be what either party wants. So it is a very legal proceeding. In Indiana, we're called administrative law judges legally, but in Indiana we're called independent hearing officers. In the IDA they're called impartial hearing officers. That's the same idea. The idea being that we have no vested interest or conflict of interest. Like there's one school, when they file for hearings, I don't take them because I used to consult with them. So you have to remove the bias. These processes, they generally take anywhere from 30 to 120 days if we actually go to a hearing, because they typically go 4 or 5 days at a time. And there's a period of about a month after it's over before the decision is rendered. So they can spread out over several months. The law says they're supposed to be done within 45 days, but in many cases that's just not practical, because attorneys always ask for extensions, always. That's just what attorneys do. So they get an extra 30 days almost automatically. And then sometimes what happens is there may be a motion for an independent evaluation that has to be done. That may have to be done before we actually get to the hearing. So there are a number of things that can really affect it. The longest one I ever had was 9 days, and it was spread over about 3 months. And I can tell you from experience, I've never had a hearing ever where the school psychologist did not testify. It always happens. So if you're involved in one of these things, the chances of you having to testify are extremely high. If you were involved in the case, like particularly if you did the evaluation or did some consulting. So it's a formal legal process, but it's a little more relaxed. I don't wear a robe. I don't use a gavel. Occasionally they call me Your Honor, which is kind of cool.
Do you need to have a law degree?
No, I do not.
Okay.
Indiana is one of the few states that does not require a law degree. Most states do. Indiana actually now does. They changed it here a few years ago, but because I've been doing it so long, I'm sort of grandfathered in. There are probably half a dozen to a dozen states that still allow non-attorneys to do this. But they're getting increasingly litigious, increasingly complex legally. So increasingly states are going to requiring that attorneys. Makes sense. I've been appealed, though, and I've never been overturned yet. So so I'm doing something right, I guess.
Yeah.
Okay.
And then when the hearing is over, then I issue a written decision, and either party then can appeal it to federal court, or state or federal court. Usually it's federal court, and that's ones where I've been appealed to federal court. I've not been overturned yet. I think 4 or 5 times, I believe.
Wow.
So that's basically how the mechanism works. It's usually the parent who files the request, and then it goes from there. Schools can file a request, but they're much more restricted. They really can't file a request for a hearing unless the child's already in special education, and that they dispute the parent's continuing of the services. But they can't actually initiate a new hearing now if the parent doesn't agree to place the child or doesn't agree to evaluation. The school cannot initiate a hearing. They used to be able to do that before 2004. They cannot do that anymore. So, but anyway, if we have a hearing, they typically again go 3 to 5, 6 days, spread out probably over a couple of weeks, issue a decision, and that's basically how the process works.
Very cool. Can we see if we got the PowerPoint? So I'm seeing the PowerPoint. Are we able to? Can you scroll through a couple slides so that we can make sure that it's working for everybody?
Okay.
See, I'm not seeing anything, so I think that you need to. Are you in full screen mode? Because if you are, you need to come out of full screen mode.
Okay. Let me.
Are you out of full screen mode?
Okay. Let's see here. Yeah, all I see is myself at this point. Again, I apologize. I'm not used to this. So.
Okay.
Okay.
Okay, there we go. So yeah, if you just scroll through it like that, we'll be able to see it. So
Okay.
I see your mouse moving around, so that's good.
Okay.
It can't be full screen for some reason. Google Hangouts doesn't like it.
Oh, okay. Okay.
And I hear Darth Vader in the background. Anybody else?
Okay. Well, what I have here, what you see probably is the last definition of the last part of the definition, and the one there at the bottom is the one that really causes most of the problem, both in terms of practice.
Sorry, we're not seeing that. Did you go back to full screen mode?
What I'm seeing now is a full screen mode of my slide.
Yeah, you need to be out of full screen mode. Sorry.
Yeah. We're still on the title slide.
Mm-hmm.
Okay.
I can pull up your slides on my end if that works.
Okay.
Yes. So if you just scroll through it, it's a little bit backwards, but if you just scroll through it, we'll be able to see it. Yes.
Yeah, there we go.
Yeah,
Yeah.
now we see it. Good.
Right.
Thank you.
And so anyway, the slide you see there is the one that causes a lot of the problem is the social maladjustment. Again, not every state has that in the definition. Indiana removed that some time ago, and that really probably causes most of the problems legally, because the question then becomes, is the child emotion disturbed or not, or is the child emotion disturbed and socially maladjusted, or if the child's only socially maladjusted, do they qualify for services? Are they eligible? And that's the one that probably causes the most trouble, and has been the subject of numerous lawsuits against schools because of perhaps trying to deny student services. And then the next slide, you see a lot of the problematic issues with the definition, and again, because of time, we're not going to be able to get into this. I think you can read it. The one point we'll make down there is that the third dash point. This is the one that causes a lot of problems, and I've seen this in hearings. I've seen this with regard to how people interpret this. Many people believe that if you have an emotional disability or disturbance, whatever term you're using in your state, the question is, does it only apply to academics, or does it also apply to behavior and social emotional development? Some states, and I know some school psychologists, basically mean that it only applies to academics, that you have to be really falling behind in your academics, grades, not turning in homework, failing tests, those kinds of things. And if they're not doing that, despite whatever the behavior is, if they don't have the academic part, in other words, it's conceivable you could have academic problems, but or behavioral problems, but not really affecting academics, and that becomes a real issue. The federal law basically talks about functional performance, and so basically what educational performance is, the way that most of the case law I've seen, not all because some have broken this apart, is that educational performance does include academic and behavioral and social emotional functioning. So if a person's doing well academically, but having a behavioral problem, some people would say, well, they don't qualify. That's not what the law intends. But there is some case law that has been exactly the opposite. That says if they're doing fine academically, then they're not emotion disturbed. That's not the intent of the federal law, and that's not the way the most hearing officers are going to interpret that. However, in some states where you have that, it may be very different with regard to how people interpret that. And there's actually some case law in some states. I think it's one of the eastern circuits up around New York or out in that area somewhere, where they actually have defined that as being academics only, but that's not really what the law says. In Indiana, we don't have that exclusionary criterion, so it's not as much of an issue. But in some places, it could be an issue.
Okay.
So let me move down here to another slide or two. And that, again, that's really the key issue, the key debate. And the way that a lot of psychologists sort of interpret this emotional disturbance and social maladjustment exclusion is a pretty popular way. We're all familiar with internalizing and externalizing patterns. And what a lot of people do is interpret emotional disturbance as being primarily internalizing, and social maladjustment as being primarily externalizing. It may be intuitively makes sense, but in fact that actually doesn't work, because I'm sure most of you know, if you look at the correlations between internalizing symptoms and externalizing symptoms on just about any behavior rating scale or any other measure, they're correlated about 0.5, positive 0.5, which means as one goes up, so does the other. So it's really not a real reliable way of distinguishing emotional disturbance from social maladjustment, but that's commonly the way people do it, and in most cases they're probably doing it wrong by doing it that way. The point being, you need to be really looking at just a wide range of symptoms and so on. Again, to a large extent, it's a clinical judgment. It's a consensus of the case conference committee, or whatever term you use in your state. Federal law calls it the IEP team. In Indiana, we call it case conference committee. So this is one of some of the bigger problems, and that basically what the law says is if you were going to use this, the child would have to have internalizing problems. They might have all externalizing problems, but if they only have externalizing problems and no internalizing problems, that's social maladjustment. It's not emotional disturbance. But in fact, most kids who have acting out problems, even if you look at this, if you even look at them on things like behavior rating scales or self-report measures, they oftentimes don't show up as clinically significant, but they frequently do have a lot of sub-symptom level kind of thing, which probably still says that they have things going on. And many of these kids actually have a lot of anxiety that again does not show up on an anxiety scale like a MASC or the RCMAS or something like that. But they do have a lot of clinical anxiety, which probably says that that's underlying it. So, and the way the law is that if there's a doubt, you always give the benefit of the doubt to the child. So basically, on that 10th slide there, you really can't rely upon the internalizing, externalizing dimension as the only way to do this. And in fact, one of the things you have to be very careful about when you're looking at ED is some people they'll use a difference between an internalizing score and externalizing score or whatever else as sort of like a cut point or something like that. Federal law specifically prohibits in all areas of eligibility schools from using any single measure, any single criterion to determine eligibility. So that's why it gets really much more complicated in doing ED assessments, because there's just a lot of information that's inconsistent.
Mm-hmm.
I don't know if that gives you a perspective. I'll stop and see if there are any questions from anybody before I go on a little further here.
I have a question. I was just looking at one definition of social maladjustment and it versus emotional disturbance, and it seems like the main in different behavior areas such as school behavior, attitude towards school, attendance, peer relations, the main difference was that a child with an emotional disturbance can't help their behavior, whereas a socially maladjusted child is just unwilling to change their behavior. Is that a way to determine one from the other?
Well, it's certainly a way that's been proposed, but it's the difference of again can't versus won't.
Mm-hmm.
And the problem is we don't have a really reliable way of determining that, but it certainly is one way that people do this. And if you had a way to reliably measure that, it could be a defensible approach. It may not necessarily be accurate, but it could be a defensible approach by saying the child is so anxious or that they simply can't participate or whatever else. Whereas a kid with social maladjustment, that they choose to misbehave. That intuitively makes some sense, but many kids come from most kids who have social maladjustment, as a general rule, tend to come from dysfunctional families. So how can you say that they're not bringing things to school with them in terms of emotions, feelings, fears, anxieties, anger, whatever else that's not spilling over into the school? So that's a popular way, but I'm not sure it's the best way. But that is one way people do it.
And given how loosely, I mean, you mentioned how there isn't really a particular definition for social maladjustment, and then even if there was, it's they can be socially maladjusted if they're also emotionally disabled or disturbed.
Right.
So as school psychologists, how important is it for us to address in our evaluation social maladjustment, or is it something that we shouldn't even really be concerned with? Like, how important is it?
Well, I think to some extent it's going to depend on what your state says. My feeling is, and what the law reads, that if a child really does have some significant emotional problems, but they're also, and they may or may not be having some behavior problems, it's probably interfering with their social functioning, and it may or may not be interfering with their academic functioning. So generally, I wouldn't spend a lot of time trying to differentiate them. To really try to establish the impairments that are being caused by these behaviors, whether they be academic and or social, and really base the eligibility on that. and don't really pay as much attention to social maladjustment. Now, you will have some people who disagree with that. That's fine. But legally, you're certainly on safer ground, because what happens if the kids are determined to be socially maladjusted, they are basically then left into the general education population. The risk of dropout, the risk of greater problems increases dramatically, and the risk of school failure. So I think in many respects, if you think about this with regard to the kids themselves, you're doing a disservice by not giving them something. Now, if you didn't find them eligible, but there was still a really good program, maybe under Section 504 or some kind of school program, that can still serve the same purpose. But just to, because what I see is a lot of schools and a lot of case conference committees spending an awful lot of time trying to say, is this child emotionally disturbed or socially maladjusted, when in fact they should be really thinking, what can we do for this kid? And the law is not going to give you grief if you include a child who is marginal in terms of social maladjustment versus ED. They're not going to give you a lot of grief, and it's probably not going to go to a hearing if you do that. So you're going to be legally defensible by really not placing very much emphasis on the social maladjustment and really trying to just differentiate that. There are actually a couple of scales out there that attempt to distinguish between emotional disturbance and social maladjustment. If you really look at them, they're both, the ones I'm familiar with are based upon emotional disturbance being internalizing primarily, and social maladjustment being externalizing. Again, that's probably the way the items or the scales are constructed, but we know from research that they're not that clean. So I would not spend a lot of time trying to differentiate. I'd try to find a way to evaluate for what the child's needs are and go from there.
Okay. You know, this might be a good spot to just talk about our poll for just a second, if you don't mind, Dr. Huberty.
Sure.
So we have a poll on the School Psyched podcast page that talks about what specific methods school psychologists are using in evaluations. So, you know, one score criteria really gives us enough information. So I'll just read through what other psychologists are using in response to the poll. We had 23 people respond that they're using observations across all settings.
Okay.
We had 23 people respond that they're using parent, teacher, and student interviews.
Okay.
21 people responded that they're using general behavior scales such as the BASC or the CBRS.
Okay.
19 people are also assessing academic achievement, so looking at the impact on the academics. 18 folks, school psychologists, are using cognitive assessments as part of their battery.
Okay.
9 people responded that they're using ED-specific scales, so just as we were talking about, so like the ED-DT, the SAED, the BDI.
Right.
Construct-specific scales to target things like depression, executive functioning, anxiety. We had 8 psychologists respond positively to that. 7 people are using response to intervention. So I responded to that. What I do a lot is behavior interventions to just give the kid specific interventions for a certain period of time if I'm looking at in emotional disturbance, just to see if I can get the child to respond positively.
Sure.
5 people are using projectives, including sentence completion, and then we had 3 people using ED-SM checklists.
Okay.
So along with that, we talked about how many school psychologists are doing typical ED evaluations in a year. We have the majority of us are doing 4 to 6, with 7 people responding to that one. 6 people responded that they're doing 0 to 3. 2 people responded that they're not typically doing ED evaluations in the setting that they're in. And fewer people are doing 7 to 9 or 20 plus. And then the last response was working in a setting where ED evaluations are a big part of the job. 2 people responded to that. So I don't know if this is a good spot to talk a little bit about what you might think would be a good evaluation in terms of looking at some of the criteria, or at least maybe some tips for those of us doing some of these?
Okay, I've got a list. I didn't give a specific list, but let
Okay.
me find the slide here. Okay, and it's on slide 15. This is what I would recommend that you do as a minimum. The thing you want to be able to do is, first of all, obviously, identify the specific needs of the child and characteristics. But these are the things I would recommend as sort of minimal. And there's actually another slide in here that talks about the Supreme Court has actually identified what a comprehensive evaluation is. And that's a little further down. But the behavior rating skills by parent and teacher, and if you use something like the basket, the self-report measures as well. But I would recommend it to the extent possible, and the law it depends on your state how much they require this, but at least one behavior rating scale by a parent and teachers who are involved and know the child the best. Systematic observations, which most people do. Self-report measures. What I mean by these are probably specific measures to get into, again, depending on the referral. I recommend that in all these evaluations that everybody do at least one self-report anxiety measure and at least one self-report depression measure. And as appropriate, the other one that comes up quite a bit, is actually some kind of an ADHD checklist, like the Connors or something like that. But I generally recommend that you at least do an anxiety and depression measure, because clinically it's very easy to miss it if you're particularly paying attention to things like the acting out behavior and so on. Multidimensional measures, these are things like MMPIs, and I don't recommend you do MMPIs in the school. But if you can find some multidimensional measures that really sort of tap into lots of different areas like anxiety, depression, and so on. Behavior rating skills measure behavioral and emotional functioning. They don't necessarily really measure emotional states, the typical mood states, and so on. Certainly clinical interviews, social developmental histories. As far as projectives, I would be cautious about relying too much on projectives, because you really can't defend them legally. If you're using them as a way to get interview information, or if you're using them as a way to, if they're not clinical information, that's fine, but I would not recommend that you use them for a substantial part of it. For example, I like incomplete sentences. I think they can really offer a lot about what's going on with the child, but using a lot of these things is really, with a lot of heavy reliance on them, is probably not a very good idea. So, that would be a minimum. In the Supreme Court case, they recommended neuropsychological functioning. What I would probably suggest you consider in many of the evaluations, particularly kids who are more acting out, some kind of a measure of neuropsychological screener, like the Brief-2, for example, or some of the newer executive functioning measures. That would probably be a good thing to add in particular circumstances. But the ones I have on slide 15, at least down to the informal measures, like projectives, is defensible. It's actually considered part of what the IDEA talks about as a multi-method assessment. It gives you all the kinds of information that you have. And again, some states have specific requirements for what you do, so you'd have to match this up with what some states require. Like in Indiana, it's required that you have measures of behavioral functioning, and it requires a social developmental history. Other states may have very different laws about that. But that would give you a pretty thorough history, or pretty thorough set of data to work from, and then further down one of the slides, and what I suggest you do, depending on what your state definition is to go through, look at each criterion, and see whether the data you have support each of those criteria in your definition. If a person's depressed, scored high on a depression measure, was rated high in depression by a teacher. I go through and actually address each of those things and actually make a table. List the criterion that you're looking at one by one, and then the other columns say whether the child meets that criterion, and if so, what is the basis for doing that, or if they don't, what is absent that they don't meet that criterion. The way the federal law reads, there's no certain number of these things you have to do. Again, it's an overall is clinical impression. So go through the definition, make a table, and then present that as the foundation for making a discussion with the case conference committee or your IEP team, and then determine eligibility that way. That's probably one of the best ways I've ever seen it done.
I like that. Thank you.
It's very defensible, by the way. If you came before me with something like that, it'd be very, very hard for a parent to dispute it, or a school to dispute either one, because it'd be the school doing it. It'd be very, very hard for a parent to dispute it.
Well, it's not.
I've never seen that done in a hearing, actually, but I still think it's best practice.
Mm-hmm.
Mm-hmm.
I've probably done half a dozen to a dozen ED hearings over the years, and the way people do these vary considerably. And so I think if you can develop some kind of a standardized way to do that, it'll provide a lot of good information. And then if you do have to get into defending it, you've really got a pretty solid way to defend.
Mm-hmm. Yeah, I like that. My district we've got a program that we plug in our information, and when we're doing ED evaluations, they do have that criteria there, and then it asks for source, and so you just list out behavior rating scale or record review or something like that. It's a small, tiny little box, and I wish that I could have kind of more space to kind of justify, but they do something similar. So.
Really, what I'd recommend when you do that is state some objective criteria, like on the BASC, then a clinically significant range. Give some pretty hard data. Systematic observations, the child was off task 85% of the time. Give some really pretty hard data to show that the child really is very different from everybody else, and that again justifies your justifies a conclusion of eligibility if that's where you're headed.
Very cool.
That's great.
So again, you can use T-scores. You can use descriptors like clinically significant. You can do percent off task, various things like that. Just come up with some really hard data that you can verify. It'll give you good information for setting up an IEP, which I think is obviously the most important thing. What are we going to do for this kid? But the other part is, if you have to explain and defend it, you've got a pretty solid basis for doing it. And it sounds like that computer program is so along that same idea.
Okay. Do you want to continue through your PowerPoint, or do you want? I certainly have a ton of questions that.
Well, we've got about just a few minutes left, so let's just. I think from this point on, I think they're fairly self-explanatory. So I'd be open to just doing some questions.
Okay, I'm going to start off because I've got like a whole list. I'm going to try and not do the whole list.
Okay.
Is there any long-term ramifications for that ED label as far as that being in the child's record? I've had kids that have looked to join the military or to be a police officer and things like that, and these are confidential records. But some of these agencies I know might ask, hey, we know you have a confidential record. You told us you have a confidential record. Can you please release that to us? And so, they're left with, do I release this? Do I not? If they see this emotional disturbance here, am I going to get into the military? Am I going to become a police officer? Do we want truly ED kids doing these things anyways? So is there long-term ramifications of that label?
There can be. I know of, I had some graduate students who, many years ago, they lived in Maine, and they lived near Bath, Maine. And in Bath, Maine, they make Navy ships, and that's the major employer. And if you have a diagnosis of emotional disturbance or whatever they call it in Maine, that at that time that would prohibit you from getting a job. And I know I did a workshop on anxiety for the Washington State a few years ago, and there's a military base near there, and it's sort of the same thing. And apparently what they can do is they ask, have you ever had this kind of a label? And if you say no and they find out later, then they'll toss you anyway. So there can be some long-term ramifications. It's usually around the military, at least that I've run into. I can see where it could be an issue for other jobs like police and security work and that kind of thing. I've mostly seen with the military, but the implications are there. Again, all of what I've heard is anecdotal. I know of no case law where this has come up, but it certainly can have ramifications. And if you think, and what some people have done is they've used the term other health impaired instead of that because of that very problem. But at least from what I understand in some military settings, that doesn't solve the problem. So there are some long-term ramifications, and that are potential. And again, if you remember, what you try to explain to people is that emotional disability really talks about how kids function in school. It's not designed to be a psychiatric definition or diagnosis, but that doesn't necessarily help with dissuading a military from making you not eligible. So there are some long-term consequences.
And that kind of, should we then, as school psychologists, be bringing this up before a parent is signing consent? Should we be saying, hey, we think that this is what's going on, but you need to be aware that this could have long-term, and that kind of feeds into another question I have, is how young is too young for this? I mean, if this is a kindergarten student, that's a tough label to put on, and should we be informing parents that, hey, years down the line, if your kid decides to join the military, this might be this could be problematic. Should we be upfront like that? And how young is too young for ED?
Well, as far as being upfront, the law doesn't require you to do that. So that gives you some flexibility. The law doesn't require it. It doesn't say anything. The law is very silent on that issue. I think if as far as informing them ahead of time. I think that's something that you might do. I would go ahead and do the evaluation and just see how it turns out first. And then that might be something you would discuss in your case conference committee. So the long-term effects. I probably would not do that up front because it may not turn out that way at all. And you may only need some minor adjustments or whatever else. So I would probably not, I would not do that at the consent stage. It's not required, and I'm not sure it would be beneficial. But if you had some real concerns, and like if you lived in an area where there's a military base that's a major employer, that might be something that you would talk about, because chances are, if that became an issue, it would not become an issue unless the child were placed and the parents agreed to it. If the evaluation was done, it probably would not even come up. So it really would come up more at the decision whether to provide special education services under an ED label. So I probably would do, if that was going to come up, I'd probably do the evaluation, see what comes up, and then go from there. It's the approach I would take. And because part of that, because it's not required under informed consent, and so probably it's not something I would do at the upfront. And then your other question was?
How young, I think, Rachel, right? Your other question, how young is too young?
Sorry,
legally,
my microphone.
Yeah, legally it can be from 5 up.
Okay.
I would be inclined to, with young children especially, because they're changing so fast. Because if a child's really going to have, if he really does have some kind of a psychiatric disorder that is spilling over into what we call emotional disability, those really aren't very stable, as you know, until probably at least 8 or 9. And even then, so I would probably come up with some kind of a different label or a different service or a different way of conceptualizing it, and not necessarily put that label on if I could avoid it. If they get up in 9 or 10, it may be a little different.
What do you think, Dr. Huberty, about DSM diagnoses leading to ED referrals? Are there some that sort of naturally do, or is that problematic? What do you think about that?
Well, I think under federal law, as you know, a psychiatric diagnosis is neither sufficient nor necessary to make a child eligible for special education. And as a general rule, they don't help. And when I actually see them in due process hearings, I actually don't particularly pay a lot of attention to psychiatric diagnoses. I really have to look at it from the educational perspective. But if you do see psychiatric diagnoses that lead to ED, more often than not, it's related to some kind of internalizing problem. Before DSM-5, things like bipolar disorder, severe anxiety, phobias, fears, obsessive compulsive kind of behavior. Those are the kinds of things that are probably going to be more clearly what we would call emotional disturbance, and that are probably going to show up. And the anxiety disorders are going to occur much sooner developmentally than are the other disorders like depression and so on. And so a diagnosis of a psychiatric diagnosis of more the internalizing things is probably a reasonably good indicator if there's something going on. But again, you still have to put them in the context of how that's affecting their behavior at school. So, and you should not just use a psychiatric diagnosis to determine eligibility. You really have to do your own thing. I've had a couple of situations where pediatricians have given me diagnoses of ADHD, and they say, and maybe perhaps you've seen it. I've talked to a lot of people who have actually received a prescription for special education on a prescription pad.
Yes.
You've probably seen that. That carries actually no weight legally. You still have to do your own thing, and just because they have it doesn't mean, and a physician prescribes it, doesn't mean that that's required.
That can make parents really, really upset, and when that happens.
I don't know how many school psychologists I've talked to said, "Oh yeah, I've seen the prescription pad thing." You've probably seen it too.
Yes.
As far as psychiatric diagnosis and whatnot, what if you have, say, a mood disorder type kid, where we've got these ups and downs, but when evaluation time comes around, we're stable and we're good. I know that the law has the, over a long period of time and to a marked degree type of thing going on. When you've had a period of stability for 3 months, where does that leave you?
Well, I think the law is designed to be pretty flexible, and we understand. And if you actually go into a legal proceeding, a psychologist will testify, well, sometimes these kids do pretty well, and sometimes they have harder times. And so what I would probably do in a case like that is write an IEP that you just adjust, rather than say, okay, we've now had 3 months, let's dismiss him. Let's just track it for several months. If the child's doing well, then and whatever you did is working, then you can begin thinking about perhaps deciding he no longer needs the services, perhaps at the end of a school year. I wouldn't do it too quick. And the long period of time criterion is really kind of iffy, because you have situations where the kids may have started some of these behaviors in the previous school year. It's carrying over to the current school year, and so you have to go back and look at the history across perhaps several months, including across school years. But if they finally reach a point where they're stable, then what I would probably do is rewrite the IEP and put the child into a consultation mode, and just basically change the IEP with parent consent that they may not need this level of intensive services anymore. Put them in a consultation mode and say, we'll review this after 2 months or 3 months, and then revisit that again. If the child's still doing well, and then they say, well, he really doesn't need the service anymore. That would be the approach I would take. And it's very defensive legally, and it reduces the possibility that you would discharge a child from special education too early.
And what about for initials too? Is that important for initials? If if you don't necessarily have the documentation of maybe these psychiatric type behaviors because we're in a period of stability, but you have this maybe history of hospitalizations and a history of this, but you haven't seen it yet because we're stable. Does that matter? Or?
Yeah, in that case, just the history itself is enough. Even though you haven't seen it, the history is enough to establish the pattern. And then what you would do is, when you get into doing your own evaluation, consider that historical information. Because basically what the law is really more relevant to Section 504, but it actually applies to IDA. If a person has a history of behaviors, they are assumed to be, the school's actually been essentially put on notice. The child might have problems, even though they may not be showing it currently. So then what you'd have to do is establish current levels of functioning and whether the child currently requires special education services. And so I would go with the history, do a current evaluation. It depends on your state. Some states may allow you to do what's called a diagnostic period, where basically you can create like a temporary IEP or a temporary plan, do some initial observation evaluation, see how they do before you actually maybe do a full evaluation or actually determine eligibility for special education. That depends on your state. Indiana does not provide for that kind of thing. They used to. So your state may allow you to do some kind of an observational period or diagnostic period to gather more practical day-to-day information without necessarily relying only on a kind of a one-shot psychological assessment. And if you can do that, and particularly if you have a sort of a period where the child's doing pretty well, you can treat that as an observational period and diagnostic period. Again, depending if your state allows that.
Okay. I'm wondering, Dr. Huberty, and this is just out of curiosity, I guess, but I'm wondering what comes to court more in your experience. Is it the school says the child is not eligible, or is it that the parents are saying the school isn't providing the right services after eligibility?
With ED, frequently what happens, there's actually the first two. Sometimes what a frequent complaint in general special education, the school's not implementing the IEP properly. But in cases of ED, what usually happens is the child's been suspended for misbehavior, or the child's had all these problems, and the parent is saying, the child has this history of problems and you're not doing anything. I actually had one case where the school didn't identify a girl with some obvious emotional disabilities for a year and a half. And I actually ordered 270 hours of compensatory education because the school dropped the ball. I had another case where the child was 15, was doing pretty well, had some mild problems, all of a sudden his behavior got worse. And it turned out he's being sexually abused in the school. Again, that wasn't the school's fault, but his behavior really deteriorated. The school did nothing, and I cited the school for failing to adapt his IEP to the new circumstances. So most often it's about identification of, at least as far as ED in my experience, and less often about implementing the IEP, although that has happened as well. And one of the one ED case that I had that went to federal court had to do with a child who had contracted what's called Pandas. It's a neurological disorder which causes a lot of psychological symptoms, and the parents alleged that the school didn't program for it because it was a medical condition. The school was wrong, but they finally got it cleared away. But the school said, well, it's a medical condition, it's not ED, so therefore the child doesn't need services, and that's not the case. The school was wrong on that one.
Yeah, hearing about your cases are so interesting. Is there anything that really stands out for you, or anything that's really interesting, or any tips for school psychologists, or what not to do that anyone who's going maybe into a hearing type situation?
Well, I think I've done a lot of workshops, and one of the things I talk about when doing school psychological work and that kind of thing, it's sort of my real estate analogy. You know, when you hear about real estate, it's location, location, location. In school psychology, it's document, document, document. Document everything, and because if you document, they can back it up. It's really hard to challenge it. So particularly that's why when you're doing ED, that's why comprehensive assessments are really important, and using pretty objective criteria. When you go into a hearing, then basically just it's usually going to be a parent attorney, not always, but usually a parent attorney who's really going to challenge your data. They will not challenge your skill. They will probably challenge your data. As long as you have really objective data, and again, using some kind of a matrix like I talked about or something like that, you can say the child had this and this and this. The hearing officers really is most often always going to defer to the educational expertise of the psychologist. Hearing officers are not supposed to interject their own opinions. Like I see in my hearings many times where I wouldn't have done it this way, but I can't say anything because my role is not a psychologist, it's to be a judge. So documenting these things very specifically, addressing the criteria, and being able to explain these things very well. Know your psychometrics. I had one, it was an ED hearing. The school psychologist said, the parents' attorney said, our IQ scores standard scores, and or normative scores, and she said, sure, and she said, and our subtest scores standard scores. And she said, well, no, they're really not, but she didn't, but I don't know what she was thinking about, but they are standard scores. They're scaled scores, but they're standard scores. And so it kind of undermined her credibility a little bit. Mm-hmm. So really knowing your stuff and knowing what the tests measure, knowing what the criteria are and what is a clinically significant level of dysfunction or whatever else, those are things that really will protect you. And it doesn't mean you're going to be less nervous, but you'll be able to walk out there feeling like you were able to accurately represent the data you had and the conclusions that were made.
Yeah, wow. That's a great tip.
Yeah.
Okay.
Yeah, you really have to cover your bases, and particularly with ED, because it's so much more subjective than the others. You really have to do your homework and really nail this stuff down and be able to integrate the information. The other thing you have to be prepared for too is, as you know, sometimes the data are discrepant. A parent will be different than the teacher ratings, for example, or the parent will say, my child doesn't do that at home, but they do it at school. You've heard that numerous times. Right. You have to be prepared to explain those differences, and there may be things like you can say, well, the child behaves differently at school because the expectations are different. Mm-hmm. And these are the expectations at school that may not be happening at home. And so be prepared to even explain the discrepancies as objectively as you can.
Awesome. All right, I'm thinking that we'll look to wrap up. Rebecca, any questions from our audience? Anybody have any comments before we wrap up?
Nobody does. I got some likes on our Facebook on the podcast page. I posted a couple of quotes that I pulled from what Dr. Huberty was saying, and a couple of other relevant articles. But everybody, I think, is just taking it in and kind of hoping like I am, that they're never going to be in court.
The chances aren't great, but they're always there.
Yeah.
And in fact, I've had a situation where a couple of my graduates have actually had to testify in front of me. That's a little weird.
Oh, dear.
Yeah.
That's a little weird.
That is.
Wow. that
I agree that it's weird.
Yeah. Who would you say is the school psychologist's best ally in these kinds of situations? Is it other school psychologists in their buildings, or is it administration? Is it the hearing officer?
Well, I'd say it's probably other psychologists in your district. You really can't access the hearing officer directly, but if you're in a hearing, and the chances are you maybe not called to one of these hearings, but you might have testified in a child abuse case and so on. Mm-hmm. If there's some certain tips I can give you is, answer the questions. Make sure that if you ask a question you don't understand, ask them to repeat it, and to where you can understand it. Don't let them sort of bully you into giving an answer that you're not prepared for. But at the same time, don't say more than what the question requires. If it's a yes/no, it's a yes/no. If they say what's clinically significant, define it. But don't give more information than the question they ask, because it's a very easy way to get tripped up. I've seen it happen many times.
Really, really good advice. I would need to stop myself. I talk too much.
Yeah, you have to be careful about that, because attorneys are skilled. I mean, there's actually an axiom in law, and my friend is an attorney. He said that basically, in general, attorneys don't ask questions they don't know the answer to already. And so that's why you need to be really careful that you've really got it down, so they really can't challenge you. and sometimes they can challenge you by turning a word around. But just be objective, give brief, direct answers, and if you don't understand something or need to say, I can't answer this question, yes or no, turn to the hearing officer and explain your position. Generally, in these kinds of hearings, they're much more flexible, and the hearing officer will generally give you the benefit of the doubt, because this is not like court. It's court-like, but it's not like being in court. So you've actually got some flexibility, and use the hearing officer to your advantage to make sure that you can communicate what you want to say. That happens a lot, actually, and that's the way it should be.
Very cool. I've got one more quick question I wanted to sneak in there, and then we'll wrap up for tonight. But I just wanted to know, as far as like research-based interventions and counseling as a related service, like counseling as a related service, would you expect most ED kids to have counseling as a related service? And then just what research-based would, from a legal perspective, what is considered research-based, or where should we be looking to for that?
Well, there's actually not been a lot of case law on scientifically based instruction in terms of challenges legally. There's not actually been a lot of case law. But if the child, as you know, if the child requires counseling services to make progress in education in the school, what I would really focus, the two or three you're probably going to be able to do in schools most readily are more behavioral approaches and cognitive behavioral approaches. Those have the best research behind them. Some people do solution-focused therapy because that's more practical in school, and there's certainly research for that. Those are the three I would probably focus on primarily. I would not go into using a lot of generic, dynamic kind of counseling, because first of all, it doesn't work as well as the others do, and it's much easier to show what you're doing and defend it. Like if you're doing cognitive behavioral therapy, you can have homework assignments, things like that, and those are scientifically based, and it's going to be much easier to do those kinds of things in the schools. It's also going to be much easier to show that it's scientifically based. The biggest scientifically based dispute we have right now that shows up in hearings is the use of the applied behavior analysis things with children with autism. That's the one that shows up most often, but there are others.
Interesting. I thought that was very evidence-based.
It is. But it's very evidence-based, but what the dispute is does the school have to actually do it? And in many cases, they don't, even though it's evidence-based. There's a question whether they have to provide that, and that gets into whole legal entanglement here. Probably more time than we have to get into here. But but use evidence-based, and when you're talking about counseling, again, those counseling broadly defined, behavioral approaches. Positive behavior support approaches, I include that as well. Cognitive behavioral therapy and solution-focused therapy, those are the ones that are probably the most practical, that you can maybe show some results, and that you can probably do fairly realistically in the school setting.
Fantastic. Well, Dr. Huberty, I know we are running over time, so we're really grateful for all of your thoughts, ideas, and sharing your PowerPoint. And I know we may have some residual questions afterwards on the Facebook page, or email to us. So if it's okay, if we come up with other questions, can we send you an email?
Sure. And if you come up with a lot of questions, I'd be willing to do like another question and answer thing with the group at some point down the road.
Great.
Great. Thank you so much.
I'd be happy to do that, and maybe by the next time I'll have the technology figured out better.
Well, this is fantastic, and I know we've benefited from it, and I'm sure the rest of the psychologists in the listening.
Well, this is part of a larger series of workshops and things I've done. It's even more complicated than what we've talked about here, but hopefully this will give you some sense of what it's about, and there's more we could talk about in a 3 to 6 hour workshop, but hopefully this will give you some sense of where I'm coming from legally and from the practice perspective.
Definitely. It was so helpful. We'd love to have you back in the fall or next winter, or whenever you'd like to come back, actually.
Well, let me know, and let me know. We'll figure out a time.
Great.
All right. Thanks, everybody.
Thank you.
Thanks, everybody.
Have a good week.
Have a good night.